Divorce is a time of great pain in most people's lives. Their families are threatened, their finances are threatened, the future is filled with anxiety and unknowns. When you work in a process out of court, you have the opportunity to minimize your anxiety, the stress, the hostility, the adversarial positions. You have the opportunity to learn how to develop a proper communication, how to speak to each other, how to be civil at family events. You learn how to resolve issues that will come up in the future. It's a very good process, and people who are contemplating a divorce, even if litigation seems a possibility, should see if these processes out of court might be suitable for them. Well, a couple could get a divorce without going to court by trying to work out the issues between them, but they're ill-advised to do so. These issues have legal and tax consequences, and they should have an attorney involved. They could do this by seeing an attorney mediator, and the attorney mediator would act as a neutral, would work with the couple, help to develop the agenda, would help the couple develop information, help them to establish their priorities, remind them of some of the interests they may have forgotten that they have, whether they're personal or financial, and then help them to reach an agreement. They would then want to have individual attorneys read that agreement for them, for their own selfish interest. That's to protect them. Another way that they could approach divorcing out of court is through collaborative practice. Collaborative practice offers the divorcing couple an opportunity each to have an attorney on board as their own private counselor during these negotiations. You have two attorneys who are not only working individually with their clients, but they're working with each other. They're quite committed to helping the couple through a divorce, and they have to maintain a distance and keep their client secrets confidential, but they also have been trained in how to work with the other attorney effectively so that you have a more holistic approach, and you also have a fuller development of all the issues. You have transparency because people are committed to being honest and laying all the issues on the table, and that's a difference in collaborative law, because in mediation, the mediator is a neutral, not representing either of the people. Collaborative practice affords the opportunity to work just with the two attorneys or to expand it into a multidisciplinary team approach. When you choose a team approach, you don't need to have all the possibilities in your particular case, but you do have available for you a coach for yourself, a coach for the other spouse, and the coaches are there to help you to focus on the negotiations and to be effective, not to perform therapy. You have a financial neutral who stands by ready to give you various scenarios developed. How taxes work out, what are the financial possibilities, should you sell your house? There are many different things the financial neutral can get into very effectively. And last but not least, you have a forensic psychologist who has tremendous training in court but isn't using the court procedure to help the couple. The psychologist will speak with the children, develop some issues, and put them on the table so that the couple and the attorneys can work through them, and will be available to offer some guidance. Clients are often concerned about undertaking a team approach to collaborative divorce because there are different players involved, and all of these people do earn their professional fees. But the lawyers are usually the most expensive of the team, and having these other professionals cuts down incredibly on the lawyer time. There's also an efficiency. Each of these people is trained to handle one aspect and one approach, and by offering this to the clients will be more efficient. The process is usually a small fraction of litigation, but there are collaborative law cases that are more complicated and will take some time. Any process in which a couple has had an opportunity to develop issues and to craft an agreement to be unique for their own personal situation is a good process. So an agreement that's come through collaborative law probably is a very, very durable agreement. And in addition, the couple has learned how to talk so that if issues come up, they will be able to know how to resolve them out of court in the future. In mediation, a couple is working with one neutral person, and that person's greatest responsibility is not just to develop all the issues, but to see that there's a balance of power at the table. It's a wonderful process and very effective for some couples, but it might not be effective for all of them. If there's ever been domestic violence, if there has been intimidation, if one party is not sophisticated in financial situations and is unlikely to develop confidence through this process, perhaps mediation isn't going to be the right approach. Collaborative law, you have an attorney working with you on your side all the time, but you have a lot more chefs stirring into the pot, and with that come many advantages and a few disadvantages. And the advantages are you get the benefit of the expertise of a full team of people who are really good at what they do. And the disadvantage is that once in a while there are too many people involved, and it's like the old telephone game, so that communication has to be straightened out. But if people do their job effectively and skillfully, either of these processes will help a couple, and it's up to the couple to shop and to find the right process for themselves. Within every state there are bar associations, and there are local bars, there are state bars. People who are looking for mediators or for collaborative professionals would turn to their bar associations. They might get on the web and Google. They would find out that there are some associations that are statewide and that there are local members. Most of these people would have their own websites linked to these various sites for the associations. In the United States, the IACP is the International Association of Collaborative Professionals, and their website will direct people to every state. And within every state, they will find lists of members, they will see their training. It's not difficult to find a collaborative professional. Mediators, you will find the same thing. There are many associations, and people should do their research, and they should always remember that they want to interview the attorney and develop a comfort level. They don't have to choose someone to work on the most intimate issues of their life and the most important issues unless they have total comfort. So it's their privilege to go around, meet a few people, and choose the one who feels right. Every state will have a different organization and their own different requirements for what they want their collaborative professionals to do. In New York State, we have many of these associations, and the one in New York City, I can offer an example, requires that the attorneys in its organization have had 5 years working with divorcing couples, that they have had a 40-hour mediation program, that they have had a 4-day collaborative law training program working with attorneys, and in addition that they have taken a similar program learning how to work in this interdisciplinary model. So you will find that the collaborative attorneys, because it's a new organization, has standards, and they're pretty uniform around the country, and people can investigate what the credentials are. Sometimes a couple will begin to recognize that the process, whichever process they've chosen out of court, is not moving forward. And it's not so easy to identify all the reasons this might be happening. I'll offer a few. One is that one of them has not been doing homework, bringing information that's necessary to be considered. One might be that someone is suspecting the other of fraud in some way. One might be that one of them is trying to accelerate the process unnaturally or delay it with no apparent reason. Well, at that point they have to pull back. They may want to get a second opinion. They may want to consult with a litigating attorney to see what they could learn about the litigation process. And they'd have to consider that all of these negotiations that they've had were privileged. as most settlement negotiations are, and that information, unless it's voluntarily offered by the other person or stipulated to as they enter a court case, might have to be sought through the court's subpoena power. People who are entering a divorce and considering the collaborative process have to understand that they'll be signing a four-way agreement, the two people in the divorcing couple and the two attorneys who will be representing individually one or the other of them. The purpose of this agreement is not only to define what the process is and what to expect of the process, what to expect of the attorney, but also to make it very clear that if one of these people goes to court, the process ends and these two attorneys must withdraw. The reason this has been formulated in this way was so that the attorneys would at all points be seen to be highly invested in the settlement process. The settlement process can be very effective and can be accomplished in some cases in just a few sessions, and in other cases it may take 6 or 8 months or perhaps even longer. But generally speaking, it is less financially lucrative than litigation would be. An attorney shouldn't be wearing those two hats, a settlement and a commitment to a settlement, and then the possibility of putting on a different hat and acting as a litigator. Well, all information is good. The more education and information you have in any case that you might have to bring, the better. But you might in fact have to have some of this information asked for through a court process if the other person doesn't wish to offer it voluntarily. None of the information is useless. You've learned something, and it's important to know what you're facing, even if there is fraud.